Welcome back to Court TV Live. I'm Cody Thomas. Now, a Georgia jury is now deliberating in the roller skating influencer murder trial. Now, we've been catching up on the closing arguments. Earlier, the defense rested without putting on a case.
Do you feel you need any additional time to think about whether you want to testify or not?
No, Your Honor.
Do you personally want to testify?
No, Your Honor, I do not wish to testify.
I find that the defendant has decided to not testify with a complete understanding of his rights.
That was the voice of Eugene Jacques, the defendant here. He's accused of stabbing his girlfriend, burning her car, and fleeing the state. The prosecution admits now this is largely a circumstantial case, but the state is leaning on the defendant's actions after the crime to prove his guilt. Police later found him in Louisiana, where he gave a fake name during a traffic stop.
Why did you lie about your name? There's a reason. Tell me the truth.
Tried to avoid getting caught.
Getting caught for what?
I was trying to get out of the situation, making that wrong turn.
What are you trying to avoid getting caught for?
He knows he's got a warrant out of Georgia already.
Oh, he does.
I didn't know I had a warrant. I was trying to avoid getting in trouble for making that illegal turn. He said I was making a legal turn as I was turning to the lane.
Why would you give a fake name to avoid getting out of a ticket?
I thought y'all maybe let me go.
Nah, that don't make no sense, man.
Police don't think it made any sense. Well, the victim in this case is Beauty Couch, a rising star on Instagram before her life was cut short in August of 2023. She was only 22 years old, found stabbed 81 times. All right, let's get you back to court for more of the state's closing arguments.
At 9:30, we have the defendant hitting this area. Now, if you recall, that's at 9:27 and 49 seconds. When you're looking at the sector that's pointed at 122 degrees, and it's 0.82 miles from the tower, right? That's this big arc on the outside. So that's where his vehicle or his phone is hitting at 9:27 in the morning, and then it's just to the west of that by 9:30 when he's now turned down Joe Jerkins, and we capture him again at that Austell gas location. Then at 9:44, we have him right here at the corner by that mill, right? And in between then, from 9:31 all the way to 9:40 there, when we're on that number 2, or the tower facing the 2 degrees, right? You have all these hits that are around 7.7 miles or so from the, what's it called? The tower. So that's in these shaded lines here, right? Which encompasses that area between Austell Powder Springs and Joe Jerkins Boulevard there, okay? So that's right in that area during the time that he's there setting those fires, all right? 10:15 to 10:30, you then have the defendant going to his extended stay, right? There's a lot of other areas he goes. They're really not important. We just wanted to make sure you all knew he did not go back to that area, or at least we have no data to show that he went back to that area. But what is important is that at 10:15 to 10:30, his timing in advance is exceptionally consistent with him being at the Jacques residence or at his extended stay where he was staying, right? So we know that during that time period, and thereafter he ends up going to the racetrack. Now we know that it's after 10:54 a.m., right? Because at 10:54 a.m., he's hitting number 8. He's the farthest from the tower, so it's over here, very consistent with his flock hit at 10:54 a.m. And then as you heard Special Agent Bernie testify, he then is in the area of that number 9 hit. He didn't have that exact location, but he said he did look up the racetrack, and it was very much consistent with this general area there. From 10:56 to 11:04, the defendant stops at that racetrack. He is there for 7 minutes. That is a long time to be at a gas station, shoving things in the trash can and never going inside to get a drink, to get food, to get snacks, to pump gas. So he's there for 7 minutes. He makes multiple trips. Apparently, this whole trash can was full, so he had to go to the other trash can that's by the gas pumps. And there we see him get out of the car, shove more things in the trash cans there. Random gas station, didn't pick one close to his house, didn't pick one close to the victim's house. All right, then he pulls out, and that's at 11:04 a.m. Now, how do we really know that's him? Because you can see the vehicle. They both say courtesy there. In fact, there's a little dent in the back of his car that you can see here. This is the photo from his vehicle being processed. You see the same dent there. You then can see the tag number. You see the body side molding. You see the sunroof. You see the dark tinted windows. You can see that those tags line up. It's hard to see every single number there, but when you look at all of this, you can certainly make enough out to know that that's definitely his car, in addition to the fact that his phone records put him there. Then at 12:16 p.m., Austell PD is dispatched to a brush fire. Of course, that's off Joe Jerkins Boulevard. Not a person on fire, not a car on fire, right? Someone just saw smoke and thought it was a brush fire. That was what they were initially dispatched to. Granted, this view that you see is from Austell Powder Springs. That is not from Joe Jerkins, but you can tell there's not much to see. You don't drive by and go, oh wow, there's a dead body in a car on the side of the road, okay? 10:33 is when Austell PD arrives on scene. And keep in mind, at that point, they only know that it's just a car on fire. They actually have to go back, make contact with Deanna and so forth before they ever even know that there's in fact a human. All right, at 2:39 p.m. to 2:48 p.m., the defendant then returns to the area for the fifth and final time. All right, the fifth and final time. This is the fifth time he has gone there since murdering her. All right, this is no coincidence. We can see at 2:45 p.m., his car is captured by Austell Gas. All right, he's driving in the direction that would go to the body dump location, to that only entry-exit point off of Joe Jerkins, right? And then he ultimately ends up dumping out where Joe Jerkins takes that turn by the mills. All right, so we know that he's driven past, and at this point, law enforcement's there. We know law enforcement's there. What we also know is the medical examiner is not there, right? That's the timeline we established with the officers, is that there's no medical examiner's truck at that point in time. They had to wait for the medical examiner to arrive. So there's no indication there's a body. And even then, you're not even seeing a car anymore, right? They took the car. They towed the car. So there is nothing there but police presence, no indication of a human body. But all of a sudden, he's like, I got to get out of Dodge because I'm going to be the prime suspect in a murder? All right, so immediately thereafter, he flees to Louisiana. And I mean immediately, okay? This is important. 2:45 is when we see his vehicle that's right there at Austell Mill. By 3:13 p.m., he's already south of Atlanta. So don't let that timing confuse you at all. This is after he's been traveling south for a period of time. So he immediately flees to Louisiana. What does that mean? That means his car's already packed, and we know his phone is in it because the phone gives us the data, all right? The only reason this defendant knew what police were investigating and what they were responding to is because he murdered her and he set her on fire. There's no other explanation for it. It's that simple. It's as simple as the baby powder. That is the only reason he knew he needed to get out of Dodge immediately. That is all you could see. But he is the only person on this planet that knew Beauty was down there and she had been stabbed 81 times because he did it. All right, there's no other explanation for him immediately fleeing the state but for his guilt. But for him being the only person who knew where her body was and knew what he did to her. All right, we told you there were three important pieces of evidence: the defendant's location, the property, and his behavior. All right, defendant's in the area of Beauty's house the very last morning she's known to be alive. Right, we have him parked there at 6:01 and she's posting on social media at 6:30. That is not a coincidence that he is right there in her backyard at the last time we have a sign of life. All right, he then travels in Beauty's car. We know that from the timing advance data to Fulton Industrial. Why? We don't know. Not an essential element of the crime charged, right? And then drives back to her residence in her vehicle. Going back, so that's for a period of, I think, 8:45 to 10:23, right? So what he's doing in her car, we don't know. All right, but we know that it's completely consistent with all of the flock hits. His phone records are completely consistent with all of those flock hits of Beauty's car when we know Beauty has zero signs of life. All right, he then returns to the area of her residence in the body dump location 5 times. I told you 4 during the opening. I made a mistake. It's 5. 1:59 p.m., 6:46 p.m., between 1 o'clock and 1:06. That should have said a.m. My apologies. And there's 3 passes down Joe Jerkins at that point in time, from 9:30 to 9:44, and then at 2:45. 5 times he goes back to this area, but he doesn't drive on her street because he's not looking for her. alive. He's looking to see if anyone's found her body. All right, the defendant then flees to Louisiana after police find Beauty's vehicle and body. Again, this is before 3:13. This is immediately after he drives by that. He heads south, which means his car was packed. He had his phone. He had cleaned out his extended stay. All right, he was ready to go immediately once he found police on scene. Now, why he waited, again, I don't know, right? But that's not an essential element of the crime charged. All right, the defendant's parking citation, now looking at the property that leads us to him, his parking citation was left near Beauty's body. I understand the defense saying, well, I mean, how stupid is that? Surely he didn't leave it because it would be too stupid. Well, he did. Maybe he didn't notice it. Maybe it was an accident. Maybe it fell out when he's trying to drag full trees basically on top of Beauty, right? But somehow it got left. Not planted, but left. All right, and that citation goes back to his vehicle that we know belongs to him, right? That's the white Nissan Altima. And we know that that particular tag expired in April of 2023, which is why it's a different.
All right, let's bring in my guest this hour, criminal defense attorney Jeffrey Wolf. Jeffrey, great to see you, my friend. It's been quite some time since we've done this little rodeo together, but I'm glad you joined me on the program here today. Jeffrey, this is a interesting case here to me because from the get-go, the prosecutors admitted we don't have all the forensic things that are going to tie him to this scene. We don't have the DNA. We don't have a murder weapon. We don't have her DNA on him or inside any of his cars. All of that stuff that jurors are used to seeing. But they do have a lot of this circumstantial stuff that she's combing through, pretty effectively here. But we're in a new day and age, Jeffrey. Do you think this is going over well with the jury? I mean, people want to see that, specific, inarguable data.
Yeah, I mean, jurors not only want to see it, they oftentimes expect it. They expect the prosecution, before they get to the stage of presenting a case to a jury, to have something that is forensic, something that meets that CSI test that jurors often expect. But those things don't always exist in a case. And I think prosecutors do a pretty darn good job in jury selection most times of safeguarding against that as they deselect jurors that aren't going to fit a case like this. They go through and they find the jurors that are going to demand that evidence in a case that doesn't have it, and they get them off the jury. And so those jurors are probably not sitting in that box, I suspect.
Yeah, I mean, that makes total sense here. And Jeffrey, we're also dealing with quite an emotional case, regardless of who did this. A woman stabbed 81 times. Obviously, that's emotional. That's hard for a jury to carry, especially if there's some young women or even some mothers on that jury, mothers or fathers. I'm just wondering, if that emotional load, the people are human. They're going to have emotional attachments to what they're hearing here. Could that emotional load overshadow the prosecution's evidentiary weaknesses here when it comes to their deliberation?
Prosecution counts on that in quite a few cases. They count on the emotional weight of the case that they are trying to overcome a lot of the weaknesses that can exist in any case that they have, whether it be a low-level domestic violence case, a homicide like we're looking at here, because you're not going to find many homicide cases that are not emotionally heavy, or a sex assault case. They count on that emotional weight and how it plays with the jury. It's one of the reasons that they show the grisly photos that aren't necessarily important to show to a jury. It's one of the reasons that they always want to show those photos, even if the defense is willing to stipulate to the grisly nature of the homicide, because they want that emotion out of the jury, and they count on it to blur the lines of any other deficiency in their case. As a defense attorney, I am well aware of how often they count on that weight.
You've been in that situation a little more than once, huh?
Yeah.
Jeffrey Wolf, stand by. Folks, the jury has a question. When we return, we're going to take you inside the courtroom to see what the jury is considering during their deliberations. Keep it right here on Court TV. Welcome back. We're still in Georgia this hour, where we're following a verdict watch in the murder case against defendant Eugene Louis Jacques. Jacques is facing multiple charges, including felony murder, malice murder, and arson in the death of his girlfriend, Beauty Couch. Now, Couch's burned car was found near her body in Austell, Georgia, and she'd been stabbed 81 times, and her body had also been burned. Let's listen to more about what the medical examiner told the jurors about her injuries.
In my medical opinion, I think the scattered stab wounds and incised wounds kind of on the front of her body, the abdomen, chest, face, and in particular the sharp force injury on her right hand were inflicted before the stab wound clusters on the back of her head and on the back of her left upper back.
And what sort of indicators did you see that led you to believe the injuries to the back of the neck and the back of the head were likely later in the time of events?
I believe that those were inflicted last because they're so tightly clustered, indicating that she probably wasn't struggling very much at that point.
All right, let's get you back inside the courtroom as we finish the state's closing arguments.
What's the direct evidence that he got rid of? Well, for starters, beauty. Because if she had survived, that would have been your direct evidence. And then using fire to get rid of everything else. Fire and trash cans. I want to leave you with some final thoughts. I think all too often in a criminal case, all we do is talk about the defendant. Talk about what the defendant did, what was in his property, what was found, what his records say. And everything is about his actions. And all of those actions and all of that evidence tells you a story where you put those pieces together in order to determine what happened. But there is one more witness that we wish we could have called. Because had we had this witness, there would not be any questions left. We would know exactly what happened. Ladies and gentlemen, that's Beauty Couch. This is the only witness that could have told you everything. But we don't have the luxury of allowing her to tell you what happened. We instead have to rely on the evidence that's left behind. You heard that she was Deanna's only daughter. Deanna adopted her as a baby. Parents aren't meant to lose their children. And she had no idea that after saying prayers in the morning and leaving at 5:45 on August 22nd to go take care of other people's children, that it would be the last time she saw her own child. She had no idea that while she's with joyous little pre-K children, that this man right here was viciously stabbing her daughter to death in the woods. And leaving her there to die and suffer slowly and alone. But he couldn't stop there. He wanted to go back again and again and again, eventually setting everything on fire. So no, we can't answer why. We can't answer why this apparently lovely boyfriend of hers would stab her 81 times and then light her body on fire. But the evidence points to him and only him. And because of his actions, and because of his choices, this is all that was left. Beauty's burned up skate with her name engraved on the side.
Ladies and gentlemen, this case is about to be in your hands. It's not about getting a conviction. It's about doing what is right, doing what is just, returning a true verdict. All of this evidence that was presented, all of the exhibits you're going to get back when you're deliberating, tell one truth and one truth only. And that is that this man is guilty of every single count in this indictment.
All right, ladies and gentlemen, I need to instruct you on the law. Does anyone need a quick comfort break before we do this? You good? All right, I'm going to ask for our spectators. I'm about to charge the jury with the law. I'm going to tell them what the law is. If you feel like in the next, however long it takes me to get through this, you need to leave the courtroom for any reason, do it now. Because I'm going to ask the deputies to not allow people to come in and out of the courtroom. I have allowed that the whole trial, but I need them to listen to the law. So if you want to leave the courtroom, do it now. Otherwise, you need to stay for the entire charge.
All right, still watching along with us, criminal defense attorney Jeffrey Wolf. Jeffrey, I want to get your final thoughts on the prosecution's closing there. Even without the exact forensics, I think they walked pretty detailed through all the circumstantial stuff. I mean, she's saying these things aren't a coincidence. There's multiple things that they lined up perfectly to me as she was talking.
Yeah, I mean, what did I tell you? How did she finish it, though, right? Mm-hmm. With the big emotional flourish of let's look at the burned skate. But I don't know that I've ever heard the term, if something is too big of a coincidence, it's not a coincidence at all. I don't know if that is a well-worn phrase.
A little strong, a little bold.
Yeah. But one of the things that I always hate that lawyers do a lot is when they use turns of phrase that aren't real. If you're going to use something as a well-worn quote, use a well-worn quote that people know. But she did a very, very good job of going through all of the evidence and laying out the timeline. She did a very good job of using demonstrative evidence. Jurors love that, especially if there are young jurors on there. They expect the PowerPoints. They expect the arrows to point towards the defendant. This is all the stuff that he got rid of. And she played the hand she was dealt. Now, I'm a defense attorney. One of the things that I always love to do is I love to say that they have to put a puzzle together, and a puzzle that's missing pieces is not a puzzle that's complete. And so she really talked about how she has a puzzle and all the pieces that it's missing. If there are jurors on there that do puzzles, they're going to say, we have an incomplete puzzle. We do not have a complete puzzle. And so she used a lot of turns of phrases that trial lawyers hate. And she's obviously an experienced trial attorney, or she wouldn't be trying a homicide case and doing the closing argument. But she was very, very folksy in the way she talked about a very, very serious case. And I don't know how much I love that. Now, when cases are tried in certain parts of the country, you get away with that. But I don't know. I didn't, it's not my style.
Right. Should the defendant have testified here, Jeffrey, or do you think there would have been too much of a risk getting sliced and diced on the cross-examination?
Well, here's what I'll tell you. The defendant has no obligation to testify, so I always hesitate to say whether he should have testified or not. Mm-hmm. But I think if he had a story to tell, he should have told the jury that, in the sense that they like to hear from a defendant.
Absolutely. Jeffrey, stand by, folks. Coming up, we'll keep our eyes on this verdict in this case in Georgia, but we'll also pivot and catch you up on a murder case out of Washington State where the defendant has pleaded guilty by reason of insanity. That's all coming up right here on Court TV.
Did you have contact with the sheriff's office?
Yeah.
Why?
We found a dead body.
Now, were there visible injuries to Beauty's body?
Yes.
How many?
There were approximately 81 sharp force injuries to her body.
I'm Cody Thomas, and breaking news, we have a verdict in Georgia after just over an hour and a half in that murder case involving a social media influencer being stabbed 81 times, and the defendant, her boyfriend at the time, Eugene Jacques. The prosecution admitted the case is entirely circumstantial without direct forensic evidence, and that's exactly what Jacques' defense is trying to exploit here. Let's go into that courtroom now.
In the jury room? Yes. Was it freely and voluntarily made by you? Yes. Is it still your verdict? Yes. Have a seat. Was that your verdict in the jury room? Yes. Was it freely and voluntarily made by you? Yes. Is it still your verdict? Have a seat.
All right, we have to jump back and rewind it there real quick because it seems like they've already read the verdict, but that was the live look. So we're going to take a moment right now to bring it back just a few seconds so we know exactly what that verdict was. Let's go back in.
In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of malice murder as alleged in count 1 of the indictment, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Cobb County, Georgia, did, on or about August 22nd, 2023, commit the offense of felony murder as alleged in count 2 of the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe the defendant is guilty of felony murder as alleged in count 2 of the indictment, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Cobb County, Georgia, did on or about August 22nd, 2023, commit the offense of aggravated assault as alleged in count 3 of the.
So those were the jury instructions there before they actually went back to deliberate. A little technical difficulty as we catch up on the verdict here, but the verdict has been reached as we're trying to get there. You know, there's the sheer brutality of this crime. Prosecutors saying that Beauty Couch, of course, stabbed 81 times. Obviously, powerful evidence. Let's go back in.
All right, everyone have a seat, please. All right, I've been informed that we have a verdict. So we're going to bring the jury in. And we need the alternate as well, please. All right, everyone have a seat, please. I'd ask our foreperson to please rise. Have you reached a verdict? Was it unanimous? Yes. Has the verdict been filled in, signed, and dated by you? Yes. If you'd hand it to the bailiff, please. You can have a seat. You can have a seat. All right, it appears that the verdict form is in order. Madam Clerk, if you could please publish the verdict.
In the Superior Court of Cobb County, the state of Georgia versus Eugene Toby Louise Jacques. Criminal action file number 23-9-4710. Verdict. Count 1 of the indictment, malice murder. We, the jury, find the defendant guilty. On count 2 of the indictment, felony murder. We, the jury, find the defendant guilty. On count 3 of the indictment, aggravated assault. We, the jury, find the defendant guilty. On count 4 of the indictment, arson in the second degree. We, the jury, find the defendant guilty. On count 5 of the indictment, concealing the death of another. We, the jury, find the defendant guilty. On count 6 of the indictment, tampering with evidence. We, the jury, find the defendant guilty. This May 22nd of 2026, signed foreperson. I'm sorry, I cannot read the name.
That's Maria.
Yes, thank you.
All right, anything else from the state before we release the jurors?
Nothing from the state, Judge.
Now, we would respectfully request the jurors to be polled, please.
All right. When the clerk calls out your name, if you would please stand.
All right, watching along with us is our criminal defense attorney, Jeffrey Wolf. Jeffrey, guilty of all charges. Let me just run back through them here real quick. Malice murder, felony murder, assault, arson, concealing a death, evidence tampering. Guilty of all of those things without direct forensic evidence. Clearly that circumstantial evidence was overwhelming to that jury beyond a reasonable doubt. What are your thoughts?
Well, I'll say it here. You'll never see me sitting in a defendant's chair charged with such a thing, but if I ever am, I hope the jury takes longer than an hour and a half to come back with a guilty verdict.
Fair enough. Fair enough.
That was the quickest guilty verdict on such a serious case I have ever seen on these airwaves in a courthouse that I practice in ever. I know people want to get home, but that's a man's life. And I know it's a woman's life that was taken, but that is a very serious decision for a jury to make in an hour and a half.
That's what I was thinking. I mean, I guess we have a 3-day weekend coming up here, Memorial Day. Even, earlier this afternoon when I was informed that the jury would be getting the case or expected to get the case at some point today, I had that same thought though, Jeffrey. I was like, Friday going into a 3-day weekend. They don't want to take this through the weekend, hanging out with their families, come back on a Tuesday. But to your point, I also agreed firmly with that. We're talking about the liberty of a man here, especially with the amount of evidence they had to go through. I mean, like you said, hour and a half. What do you think sealed the deal here? I guess maybe they just accepted the prosecution's argument that his behavior after the killing was a little overwhelmingly suspicious. I mean, you have him fleeing to Louisiana, you have him using this fake name, you have him traveling, pointing strongly towards his consciousness of guilt, regardless of the lack of that forensic evidence.
Yeah, I mean, they had to have bought the prosecution's theory of the case, and they had to have bought it early, and they had to have bought it often, right? Because they didn't have enough time to go back into that jury room and read the jury instructions carefully, consider all the evidence, vote more than once or twice. I mean, they had to have come into that room with their minds made up fairly quickly and taken a straw poll, decided that their minds were made up, and waited out the clock so that they didn't just come back right into the courtroom with guilty verdicts. They had to have pretty much thought he was guilty from the word go. And that means that they didn't buy anything the defense was selling, and they bought everything the prosecution sold.
Do you also think, Jeffrey, I mean, again, 90 minutes, just over an hour and a half, that is just incredibly quick, talking about malice murder, felony murder. We have 6 heavy-duty charges here involving the murder of somebody, and that was just, lightning speed. Do you think the emotional weight of, maybe the 81 stab wounds, do you think that played a major role here? I mean, it seemed like a clear crime of passion, and 99% of the time when we see a crime of passion, it's somebody who is close to the decedent, i.e. their boyfriend, like the situation here.
Yeah, I mean, it certainly could have. It's hard to imagine a stranger stabbing somebody 81 times unless they have a serious mental illness. and there's, something that you just can't quite understand that could cause somebody to do that. Usually when there's that level of violence, there is a motive to it. But the state didn't even provide a motive. That's the craziest part. She stood in front of the jury and said, "We have no idea why he did this, and we don't need to tell you." She stood there and said that with a straight face. And so, I mean, they just connected all the dots for the prosecution without taking the time to talk about it. I mean, I have friends that have sat on juries, and it takes 15 to 30 minutes to pick the foreperson. And they came back in 90 minutes. It's crazy.
They had, like you said, they had to have gone in there already either with their minds made up or all of them are just kind of in consensus. Guys are ready to go. Let's just make a decision, which is what you hope didn't happen. But, I digress. Jeffrey, stand by. Court is taking a brief recess, and the judge says they will be ready to go with sentencing this evening. Keep it right here on Court TV. Welcome back to Court TV Live. I'm Cody Thomas. Now, the jury deliberated in Georgia for a little under 2 hours, actually just over an hour and a half, and came back with their verdict in the trial where Eugene Louis Jacques is now a convicted murderer. As we await the judge to get back on the bench for sentencing, let's take you back to that verdict read just moments ago.
All right, everyone have a seat, please. I'd ask our foreperson to please rise. Have you reached a verdict? Was it unanimous? Yes. Has the verdict been filled in, signed, and dated by you? Yes. If you'd hand it to the bailiff, please. You can have a seat. You can have a seat. All right, it appears that the verdict form is in order. Madam Clerk, if you could please publish the verdict.
In the Superior Court of Cobb County, the state of Georgia versus Eugene Toby Louis Jacques. Criminal action file number 23-9-4710. Verdict. Count 1 of the indictment, malice murder. We, the jury, find the defendant guilty. On count 2 of the indictment, felony murder. We, the jury, find the defendant guilty. On count 3 of the indictment, aggravated assault. We, the jury, find the defendant guilty. On count 4 of the indictment, arson in the second degree. We, the jury, find the defendant guilty. On count 5 of the indictment, concealing the death of another, we, the jury, find the defendant guilty. On count 6 of the indictment, tampering with evidence, we, the jury, find the defendant guilty. This May 22nd of 2026, signed foreperson. I'm sorry, I cannot read the name.
That's Maria.
Yes, thank you.
All right, anything else from the state before we release the jurors?
Nothing from the state, Judge.
Now, we would respectfully request the jurors to be called, please.
All right. When the clerk calls out your name, if you would please.
All right, still with us, criminal defense attorney Jeffrey Wolf. Jeffrey, I know you're writhing in your seat at this because it was so quick, but Jeff, I mean, it seems that the jury is not the only people moving fast here. Clearly, they want to move fast on sentencing. Juries, they're not the only one ready to get out of that courtroom today. They want to do the sentencing this evening.
Yeah, judges often do this in murder cases because there really isn't a lot of options when it comes to sentencing in many states. Unless the death penalty is on the table, it's usually just life in prison, and there's no hope for parole in most cases. And so there really isn't much to talk about when it comes to sentencing in a murder case. So there's not a lot of reason to delay it unless there is going to be a strong presentation from the victim families and they're not present. And so there really isn't a big reason to delay the sentencing, quite frankly. But at the same time, this case is just trucking right along. And I really have a bad taste in my mouth. And I think that, it can be tough. And I know we're here on Court TV, and you read the comments online when you appear on Court TV. And I know that the people will hear me as the defense wonk here and they will have a bad taste in their mouth that, you know, this justice that was got for this victim here in this case is not something that I am here tooting a horn for. I am happy for her family that they got justice if this is the person that killed her and this jury has said that it was. I don't care if he is guilty of this crime. I think that a trial of this magnitude deserves more contemplation by a jury than 90 minutes. I think that justice that is swift in that manner is no justice at all. And I think that a jury should take their job more seriously than to deliver a verdict in 90 minutes for a trial that has consequences this grave. And I think that they should take it significantly more seriously than they did.
Jeffrey, let me ask you this. You know, I have this thought pretty much with every case that we have here at Court TV, because pretty much all we cover is murder here. When the defense for a defendant here is pretty much saying my client didn't do it. We're not talking about, you know, insanity like he did it. We can see that he did it, but let's try to get him off of death row. When they're clearly trying to say this is not the guy. Okay, cool. That's what defense attorneys are paid to do. That's the job you are supposed to be doing here. Would it have helped if they presented an alternate suspect theory? Like, okay, it wasn't Eugene Jacques, but it was this person. Do you think that would have aided at all in the defense's narrative here?
Absolutely. Having a straw man is the best defense that you can have when you're saying your client didn't do it. It's not always easy to know exactly who your straw man is, but it is nice to be able to say, you know, this is a person with, you know, hundreds of thousands of Instagram followers, and anybody could have been obsessed with her and taken action against her. Putting on some sort of defense probably would have been a good idea here. To put on no evidence whatsoever was probably not the best plan. I think that if they had subpoenaed her Instagram data, they may have found some sort of obsessed fan out there that they could have pointed to. Maybe they did that and they couldn't find anything out there. I find that hard to believe. But, you know, to put on no defense whatsoever made the prosecution's job quite a bit easier. You know, you can't just rely on your opening and closing to be your defense to this, and to say that everything's a coincidence is not the best defense to put on when the only thing you have to rely on in reasonable doubt. It's not what the jury wants to hear. Like I said, you have a right to not testify in a criminal case, and that is sacrosanct. And I believe in the Constitution. But at the same time, I always advise my clients that we need to give a jury a why. Why are we right? And if we don't do that,
that's the thing, Jeffrey. They love to know the why. They love to know the why. It's like, okay, we see this thing happen. What's the motive? Who could have been doing it? Was he cheating with this person? Was she doing this, and that? And you bring up a good point, Jeffrey, that I didn't even think about. I mean, she has, you know, over 100,000 followers, 140,000 on Instagram alone, probably more on TikTok. I don't have nearly that many followers, and I get messages and comments of all different assortments from people online. I can only imagine what they would have found if they subpoenaed, like you said, subpoenaed that Instagram data or whatever. They could have pinned it somewhere else, that it could have been this person, it could have been that person. I mean, you know, the metro Atlanta area is a giant place full of all different kinds of people that, like you said, to not put on a defense, that seems a little risky. Clearly it was here. Jeffrey, I've been informed that the judge is back on the bench. Let's go back to that courtroom right now.
I'll let Mr. Lumpkin talk with his client.
Thank you, Your Honor.
Would you like to make an opening statement? The state has declined. All right. So I will ask the state if they have any evidence in aggravation.
Judge, we just have two victim impact statements and then just argument.
All right. I'll hear the victim impact statements.
At this time, the state would call Christy Thurman. Judge, would you like Ms. Thurman at the podium or up on?
The witness stand, I think, would be appropriate.
Hi.
If you'll state your name for the record and spell it for the court reporter.
Okay. It's Christy, Christy. Last name Thurman, Thurman. Want me to start over?
That would be great, thank you.
Okay. First name is Christy, Christy. Last name is Thurman, Thurman.
All right, Ms. Thurman, for the court, if you can tell the court what your relation was with Beauty.
I am Beauty Couch aunt, Deanna Thurman's sister.
All right. And Ms. Thurman, I understand that you wish to give a victim impact statement, so please tell the court how this case has affected you.
Yes. On behalf of my sister and myself and my extended family, this has been very, very hard because in a short period of time, this has been very difficult for us simply because Beauty was a gift to us. So we think that she's a blessing to us. She's a gift to us. And anybody that knows her know that she is very infectious with her laugh. As my sister would call her mommy, when we started all calling her mommy. She's just such a joy, such a joy. There's no other way to describe her. I mean, clearly you all know now from her Instagram follower that she's very likable. So it has really left a big hole in our heart because, like I said, she was a blessing and a gift to us, and for her to be so already gone from us, and we can't continue to make those memories with her.
And what is your take on the sentence in this case?
I will ask, first I would like to say, Your Honor, thank you. I feel like the courtroom was ran in a very professional and impartial way, but I want the court to continue with the sentencing to uphold the law to the fullest extent, please.
Anything else?
No.
Thank you, Ms. Thurman.
Thank you.
Anything, Mr. Lumpkin?
No questions. Thank you, Ms. Thurman.
Thank you.
Thank you.
At this time, the state would call Allie Shepard.
Raise your right hand. You do solemnly swear or affirm the testimony you're about to give the court in matter and opinion shall be the truth, the whole truth, and nothing but the truth, so God. Thank you. Have a seat, please.
Good afternoon.
Good afternoon.
If you'll please state your name and spell it for the court reporter.
Ali, A''LE, last name Shepard, SHEPARD.
And Ms. Shepard, what was your relationship with Beauty?
We were friends and skate team members.
And for the court, if you can tell the court how this case has impacted you.
I've known Beauty for years, and as you guys can see over the course of the case, Beauty was a light in everybody's lives who she met. She touched many of our lives, and her being gone left a hole, not only in my heart, but in the skate world's heart. It's just not the same without her.
And Ms. Shepard, what is your stance on the sentence that should be imposed in this case?
I think that the law should be carried out to the fullest extent.
All right. Is there anything else, Ms. Shepard?
No.
Thank you so much.
Mr. Lumpkin, anything?
No questions.
Mr. Lumpkin, any evidence in mitigation or extenuation?
Nothing further other than, as been mentioned, there's no criminal record of Mr. Jacques prior to this incident.
All right, what is the sentence the state is requesting and why?
Judge, not to get too much into the facts or anything, but you've heard that.
Seems like everything is moving quick today. Just 2 victim impact statements that lasted a collective like 5 minutes. I don't know if people are just trying to get to the weekend, but we're going to stick here in this courtroom after this short break. Keep it right here on Court TV. Welcome back. We're in the sentencing phase in Georgia where Eugene Louis Jacques was just found guilty of killing his girlfriend Beauty Couch. Let's get you back inside for the sentencing.
Kind of philosophy. I don't know if it's really a philosophy, but kind of what I go back to in difficult cases when it comes to sentencing. The imposition of sanctions on convicted offenders is a principal vehicle for accomplishing the goals of the criminal law. The difficulty of the sentencing decision is due in part to the fact that criminal law enforcement has a number of varied and often conflicting goals. We have the rehabilitation of offenders, the isolation of offenders who pose a threat to community safety, the discouragement of potential offenders, the expression of the community's condemnation of the offender's conduct, and the reinforcement of the values of law-abiding citizens. Sentencing is perhaps the most important and most difficult function of the trial judge. It demands of a judge the best that he or she has in wisdom, knowledge, and insight as a jurist and as a human being. Difficult as it is to do, the judge must constantly weigh in the balance the future course of the life of the individual before the court with the judicial responsibility for the protection of the community. In this particular case, the sentence that the court will impose on count 1 is life without parole. Count 2 will be vacated by operation of law. Count 3 will merge factually. Count 4, 10 years to serve consecutive. Count 5, 10 years to serve consecutive. Count 6, 12 months to serve concurrent. So it'll be a total sentence of life without parole plus 20 years to serve. Sir, you have a right to seek post-judgment relief from your conviction of the crimes by either making a motion for a new trial in this court and or filing an appeal to a higher appellate court. If you want to file a motion for a new trial or an appeal, then you will need to file the said motion or a notice of appeal with the clerk of Superior Court of this county within 30 days. You may want to more fully discuss this with your attorney. If a motion for new trial is made and the court denies it, you will have 30 days from the filing of the order of denial in which to file with the clerk of court your notice of appeal. You have a right to have an attorney represent you on the motion for new trial and the first level of direct appellate review. And if you cannot afford to hire an attorney, the court will provide an attorney and a transcript of your trial at no cost. For your felony convictions, you have a period of 4 years from the date of your sentence in this court to file a habeas corpus petition. For your misdemeanor conviction, you have 1 year from the date of your sentence in this court to file a habeas petition. While the clerk is preparing the paperwork, Mr. Lumpkin, will you notify the Circuit Defender's Office with regard to designating appellate counsel?
I will do that, Your Honor. I'll be filing a motion for new trial to reserve those rights, and then I'll advise the Circuit Defender, and they will act accordingly.
All right. I want to confirm with the court reporter that our policy is in any felony conviction, a trial transcript is done automatically. So if you will please put that in your queue. Rule 41.3 requires that there is a certification by defense counsel that a transcript has been ordered, but I believe that you don't need to require anything else from counsel in order to get the transcript done. This should be sufficient, so you don't have to deal with that. We will schedule a 120-day status conference on the motion for new trial, and my staff will get that scheduled. Let the lawyers review the paperwork. All right, counsel, it looks like the court reporter has informed me that there's a potential that the transcripts could be ready in approximately 3 months. So please that's much faster than normal. If you could please let the appellate unit and new counsel know that the motion for new trial process will be a little faster than normal.
Did Madam Court Reporter do the pretrial motions in this case?
I don't think she did, but they've already been transcribed.
Okay, very good.
All right, still with me, Jeffrey Wolf, criminal defense attorney. Jeffrey, life without parole, an hour and a half, just about 93 minutes to put a man away forever. Your thoughts?
Well, I think you know my thoughts, Cody.
I'm beating a dead horse, but I mean, it's going along. But I mean, life without hour and a half, man. I mean, I get it. The circumstances kind of painted a picture here, but as you said, a puzzle without key puzzle pieces isn't a complete puzzle. And they admittedly said, hey, we don't have all the DNA and all that, but here we are. Man's going away forever.
Yeah, I think by the time you and I are done talking about this, it's entirely possible that we will discuss the circumstances of this case for longer than the jury did. And we certainly will discuss it for longer than the judge discussed it with the victim family. I mean, it boggles the mind. It boggles the mind how quickly a black man in the South can be put away for the rest of his life. It boggles the mind. And it's the only place you see it. You know, it just is what we do here in America.
On the flip side, though, Jeffrey, did you think that his defense kind of overplayed the bizarre evidence thing? Remember the pay stub inside the burned car, that this piece of paper just so happened to not get burned up with everything else? They leaned into that, trying to say it was planted, but they were making these allegations without proving any police misconduct, which is it's kind of a bold thing. Like, if you're going to say it was planted, show us a little bit more. Do you think they played too much into that? They leaned too much into that narrative?
Yeah, I mean, there are a lot of lawyers out there that are always looking for their Johnny Cochran or their Matlock moment, right? They want to have the time that they get to point the finger at dirty cops. But if you want to point the finger at dirty cops, you need to have a dirty cop to point the finger at. Not everybody's Mark Furman. May he rest in absolute non-peace. But it's just, you got to do something for your client. You can't just sit on your hands and watch him go away. You just can't. You have to put on a defense. You have to stand up and stand with your client. You have to stand on 10 toes at all times. You have to do it when the prosecution witnesses are on the witness stand. You have to do it when it comes time to mount your own defense. And you absolutely have to do it at sentencing as well. You can't just say, well, my client doesn't have any criminal history, which is what we just heard his own lawyer do. Mm-hmm. This entire system failed this guy, whether he did it or not.
Well, Jeffrey, let me ask you this. Since this was, this entirely circumstantial and admitted circumstantial case, is that easier to present to an appellate court? Is that easier to appeal down the line?
Yeah, he's got a sufficiency of the evidence argument, if nothing else, right? Mm-hmm. I'm not an appellate lawyer, but I know the grounds on which a case can be appealed, and sufficiency of the evidence is one of them. And so when the jury did him a favor too by deliberating for 93 minutes, because when you're making a sufficiency of the evidence argument, and then you can also point in the appellate brief to the fact that the jury deliberated for 93 minutes when they were given the case, at the hour they were given it before a holiday weekend, that is absolutely something that the appellate court can take into account when looking at a sufficiency of the evidence argument. And so,
Jeff, I hate to have to wrap you up, but we're out of time here, man. Thanks for joining us, folks. Join us next week on Court TV.